We are going to get started. Again, thank you so much for joining us. We are thrilled to bring you this webinar with information on the NCAA House settlement and just an overview and a Q&A for those of you who are looking for some more info. We were on a planning call a little bit earlier today, a few of us, and laughing that it changes constantly. And you're going to hear, we don't know yet, or we think, or we can find out, and that's okay. Keep the questions coming. We will follow up and get back to you. Use the Q&A button at the bottom of the screen to ask some of the things you might want to ask. We will either answer those in text or live as we go. If you have information that doesn't come through or you have questions you don't get answered, email us, education@nfca.org, and we will make sure we try to get you anything that we can. That is our purpose and what we are here to do. We have a wide assortment of panelists, as you can see, and we are thrilled to have them all with us. We're going to let them introduce themselves and get going with this right now. So first on my list, I have Matthew Banker. Matt, you want to introduce yourself, a little bit about what you do?
Yeah, thanks for having me. And good evening, everyone. My name's Matt Banker, and I serve in a consulting capacity in college athletics, but I've had prior stops as a administrator at a Division I institution and also at a Division I conference and the NCAA national office too. So kind of had all flavors of the day, so to speak, and excited to be part of the conversation tonight.
Thank you so much. Glad to have you. Danielle, I have you up next.
Thanks. Happy to be here. I'm Danielle Day. I work in the national office in academic and membership affairs for those that work on campus, more commonly known as we work with the compliance folks on your campus to make sure that your schools and your teams are following the rules. So I work primarily in our Division I rule space.
Thank you very much. All right, moving next, we have Samantha Ekstrand with us.
Hello, everyone. Samantha Ekstrand, zooming in from Durham, North Carolina. I have the great honor of working with NFCA as a legal counsel, so I get to work with the board and work with individual coaches and then some other coaches association and other sports. And I'm thrilled to have so many experts here tonight to talk about this important subject. So thanks, Joanna, for gathering us all together.
My pleasure, you bet. And let's see, next we have Ashlyn Hare.
Thanks, Joanna. Hi, everyone, and thank you for joining. My name is Ashlyn Hare. I am a sports law attorney in Boulder, Colorado. I'm also, at this point, a not-so-recent graduate from the University of Oregon. I was a track and field athlete there. My role in the House settlement is I represent a group of female objectors who objected to the settlement on Title IX grounds, specifically the damages portion of it. And we have an appeal now pending at the Ninth Circuit challenging the House settlement.
Thank you very much. Appreciate that. Greg, I have you next.
Hi, Joanna. Thanks for inviting me to be in the panel and good to be with you all tonight. My name is Greg Pottorff. I am a managing director in the NCAA's Office of Legal Affairs. So I'm coming to you from Indianapolis, and apologies in advance if any of my children start screaming in the background at any point during this webinar this evening. But happy to be with you all and look forward to answering any questions you have.
Now it's going to feel like home, Greg. Perfect. We are ready. Jody, you're next up.
Hi, everyone. Jody Sykes. I am Senior Associate Athletic Director and Chief Compliance Officer at the University of Oregon, but more importantly, my role here with NFCA is to serve as a compliance liaison. So I am here in that capacity tonight and to try to help with some understanding and some basic comprehension of all of this chaos. And we look forward to hopefully helping you get some of your questions answered.
Thank you. And Jeff.
Yeah, good evening, everyone. Jeff Silver. I am with the Academic and Membership Affairs staff as well. I work with Danielle. Started at the national office in 2005. I work primarily in the area. I oversee the rules interpretations in a number of different waiver areas. Since July of 21, though, really, with the interim policy, a good percentage of my time has been spent in the NIL space. So I know we'll turn to some questions there shortly.
Oh, we're going to keep you busy. Don't you worry. Thank you so much for joining. And then last but certainly not least, our Executive Director, CEO, Carol Bruggeman.
Hello, everyone. Thanks so much for joining. Yes, Carol Bruggeman, CEO of the NFCA, a Division I coach at Michigan and Purdue and Louisville for 25 years, and I now have the pleasure of serving in this role. Also do some broadcasting for ESPN, some coaching in the booth. But I cannot thank our industry experts enough for joining. Even though they work with a lot of sports and answer questions for a lot of sports, the fact that they're taking time out of their schedules to really talk to the softball community, we just really appreciate your expertise and really hope this is beneficial for all the coaches.
Thank you very much. Absolutely. And Jeff said it, for 3.5 years, whatever it might be, this has been looming and working. And your first question, probably a lot of you, is what is it? So we're going to go ahead and start with Greg. Give us a little bit of an overview, understanding the basics with this new regulatory environment, and really get in the Q&A, get those questions coming, and hopefully you get a lot out of this. So Greg, leadoff hitter, that's a big deal in our sports. Take it away for us.
I appreciate that. Again, good to be with you all. So I'm going to provide just a broad, common framework of what these three lawsuits are that are commonly referred to as the House settlement. And then I'm going to turn it over to Jeff and Danielle to talk more about the implementation, which I think may be more important to you all on a day-to-day basis moving forward. So briefly, when we say House settlement, we're referring to three lawsuits filed by former or current Division I student athletes challenging Division I rules, right? So the House case, the Carter case, and the Hubbard case. Broadly speaking, they challenged Division I rules that restricted certain types of compensation to Division I student athletes, whether that be third-party NIL, direct benefits from student athletes, or scholarship limits. Of course, there's more involved in the litigation, but broadly speaking, these are challenges to Division I rules, and the defendants in those cases included the NCAA and the 5 autonomy conferences. We've been litigating these three cases for many years, and the parties eventually negotiated a settlement to resolve all three of the cases. Now, if you are a member of one of the 5 autonomy conferences, then you are bound by and must comply with these settlements moving forward. If you are not a member of these 5 conferences, you have the opportunity to opt into the injunctive settlement moving forward, and I'll get to that in a moment. There were 2 parts of these settlements, generally speaking. One is the backward damages settlement. This is the $2.8 billion settlement that catches a lot of headlines, and will those payments will be distributed to student athletes for backward-looking damages, right? There is currently at least one appeal. There are certainly more, but there is at least one appeal which effectively stays the payment of those backward damages to the student athlete until the appeal is resolved. So we receive a number of questions from student athletes, certainly from our SAC committee, saying, when are we going to start getting that money? They're disappointed to hear that, unfortunately, that money will sit in an escrow account until the appeals of that backward damages settlement are resolved. Moving forward, though, there's an injunctive settlement, and there are various components of that injunctive settlement. For purposes of this discussion, I just want to highlight the additional benefits component and focusing on kind of 3 distinct groups of benefits that student athletes can receive under this injunctive settlement moving forward. There's, generally speaking, something called true third-party NIL, to which there will not be further scrutiny by Deloitte, who has been retained to help evaluate deals that are provided by what's commonly referred to now as associated entities or individuals. Deloitte will be doing an analysis of any NIL agreement between an associated entity or individual in excess of $600 to determine whether that deal is for a valid business purpose and meets a fair market range analysis. There's a third category of benefits, and those are the benefits provided directly from the institutions themselves to the student athletes. Those additional benefits will be subject to a 22% cap, which can be recalculated at times throughout this 10-year injunctive term. But for year one, which will be the 25-26 academic year, that calculation is $20.5 million, which D1 institutions can make or offer to their student athletes. The schools that opt in do not need to provide up the entirety of the $20.5 million, but they may if they so choose. Different components of this injunctive settlement that likely have caught your attention and that you're focused on are roster limits. As a material term of the injunctive settlement, NCAA Division I schools are agreeing to move away from scholarship limits and will now implement roster limits. For the sport of softball, I believe that roster limit is 25 moving forward. There is an additional term introduced in the injunctive settlement referring to designated student athletes. These are individuals that either were cut or would have been cut as a result of implementation of the roster limits and were on a roster last year or would have been on a roster this incoming year. Schools had to create a list and identify those designated student athletes. The deadline to do that was June the 30th. And for the remainder of their eligibility, schools may roster those individuals in excess of the 25 individual roster limit for the sport of softball, and for in excess of all other sport roster limits as well. The last component that I wanted to highlight is an arbitration component. So there is a new entity that was created, the College Sports Commission, that Jeff and Danielle may speak a little bit more about, but that new entity is responsible for investigating and enforcing compliance with these settlement terms. So the NIL, the additional benefits provided by the student athletes, etc. And so to the extent that a student athlete enters into, say, for example, an NIL deal that isn't compliant with the provisions of the settlement agreement, the CSC entity will be working with the plaintiff's attorneys, and an arbitrator if necessary to evaluate and potentially correct and or mediate that agreement before an individual is deemed ineligible moving forward. I'll allow Jeff and Danielle to provide additional information based on the questions that you all have moving forward. Last, I just wanted to briefly touch on the fact that there is also appeals that have been filed challenging the injunctive settlement moving forward as well. Those appeals will move forward in the ordinary course, but it will not in any way stay implementation of the injunctive settlement moving forward. So you all can start to comply with the new rules moving forward in the terms of the injunctive settlement as that injunctive settlement continues to be litigated. Last piece, and then I will be quiet because I want you all to hear from the practitioners as opposed to the lawyers. The incoming class of student athletes on an annual basis will have an opportunity to object to the injunctive terms of the settlement. The judge was very careful to say that we don't want incoming student athletes to release their claims until they have an opportunity to receive notice and object to the terms of this settlement moving forward. So your incoming student athletes will receive notification of the settlement and the provisions of that settlement and have a 60-day period in which to object on an annual basis again moving forward. And it will be within the discretion of the judge to determine what hearings might be appropriate moving forward on any objections that might be submitted. But we'll be going through that process on an annual basis for the next 10 years. Joanna, I said a lot, I'll pause there.
No, Greg, thank you. I appreciate that. And you've done this once or twice. I think you've had to give this spiel a little bit. I will let Danielle and Jeff jump in, and then we'll go to any other panelists that want to add. But Danielle, anything, start with you that you would like to add from understanding the basics?
I'll let Jeff kick us off.
Sure. Yeah. And I do want to dive into the questions and hear from you all. Let me just kind of talk a little bit about where we fit in, meaning kind of the NCAA and AMA and this going forward. Greg talked about the back part and then the injunctive settlement. So it's really this injunctive settlement piece that we're working with the defendant conferences and folks like you all in terms of understanding and how this new system works. So when he talks about the settlement, what we see, there's really three kind of buckets of areas in my view, at least those where we're receiving questions and that are reflected in the Q&A that I hope you've all seen. That's kind of the roster limit, the roster management portion of this. How does that work? Then the second one would be CAPS, the college athlete payment system, the revenue share and the rules surrounding that, what counts, what doesn't. And then that third big bucket is Deloitte and the disclosure. But in terms of ultimate authority and jurisdiction over this, that really lies with the defendant conferences and this new entity, specifically the College Sports Commission. So that's the entity where you've seen they've hired a new CEO, Brian Seeley, and the CAPS and Deloitte report to the CSC. And the CSC over time will have the capacity to handle questions and provide interpretations and all that sort of thing. In the interim, what we've done and what you've all seen as the national office, again in collaboration with the A4, with the A5, is create that Q&A. And since we published that, a number of questions have come up. The first real, time-sensitive piece was all the updated Q&A surrounding designated student athlete, and perhaps you all have some questions about that. But we continue to get any number of questions. So what we've done is we've set up a system whereby we still collect those questions, and your compliance folks know how to submit those. We get questions from coaching associations. The conferences get questions. We have weekly meetings with the A5 now where we set agendas. We talk through these issues. And the difference with a traditional bylaw, a recruiting rule, or a playing and practice season where the NCAA staff has the authority just to issue an interpretation, this is one where that authority lies with the A5 and with the CSC. So what we do is collaborate with them, get that answer, and then either update the Q&A, provide that answer back to the school who asked. So it's good then that we've got a whole lot of framework now to work around, and so we're trying to make that FAQ as comprehensive as we can. As you know, when the interim NIL policy was released in July of 2021, it largely provided for a fairly unregulated environment, which really did inform a lot of the terms of the settlement. So we're getting there. I'm going to stop there though, because I do want to reserve time. I'm sure you've all had some opportunity to familiarize yourself with the Q&A, have sessions on your campuses, but we'd like to hear from you all what might be top of mind, whether that's Greg's legal update or something perhaps Danielle and I can help with. And I'll forewarn you in advance, I'm going to be doing a lot of deferring to Danielle on this because she is very much the expert on that FAQ and other questions you likely have.
Thanks, Jeff. We did put a link to the FAQ in the chat, so it may not pop up for you, but if you want to go to the chat and get that link, it is there. Appreciate that updated July 2nd version available for you. And if it's not in there, if it's disabled, I will get it out in the Q&A. So either way, we'll make sure you get it soon. Danielle, anything that you want to add before we go to any questions?
No, I think Jeff and Greg covered a lot of it. I guess what I would say, and you all are already going through this, is we know this is a time of there's a lot of changes going on, a lot of changes at our level. You let in with that there might be a lot of we're figuring it out, we don't know, let us find the answer. So we just can encourage you all to continue asking questions within your organization and then asking questions on your campuses, on your teams, to your compliance folks, to your lawyers. We'll be able to give some answers at a national level, but a lot of this lies with the conferences and the schools that you all are directly engaged with. So we're obviously going to be helpful, but those folks are also going to be really important resources as you all figure out how these rules apply to your specific campuses and teams.
Yeah, that's a great point. And Matt, I know that's something that you have talked a lot about too, like really getting on the same page, right, with your sport administrator and making sure that you know what the institution is doing. While we get some questions in from our attendees, can you give us a few things that you know from working with different campuses and different administrative teams that maybe we should be asking or we should be thinking about?
Absolutely. You know, one thing that's sort of maybe hiding in plain sight is each institution really has to do and is going through a lot of self analysis about how much they're invested into this, how they're investing into this, even by sport. And I share that because I know, like a lot of us, whether it's compliance administrators, ADs, coaches, you rely on your peers around the country and people even within the same conference where you all may be getting sort of different senses of the room from each campus, that dynamic's a little different. And I guess the point is really to be proactive, and Daniel hit it on the head. This is very overwhelming. There's a lot of questions that will continue to be generated for many months ahead. At this time next year, there's going to be lessons learned, and it's still going to be an evolving process. And so I think really staying aligned with what your athletic director and kind of getting his or her thoughts on what the plan of action is and what the expectations around your program are at a real both high level and even when we get into some of the functional things that Jeff and others have mentioned about managing your rosters and so forth. But you know, I guess my first message is just try not to be overwhelmed because everyone's in the same. Everyone on this call is also, you know, navigating this process too because it's a massive sea change. So I know it's easier said than done to say don't get overwhelmed, but identify questions and have that communication with your athletic director more often than you probably ever had before. It's super important.
Thank you very much, Matt. Appreciate that. Samantha, I know you're working with coaches on the regular as well. What are the questions that you are hearing that you would like the group to address, or what would you encourage those to consider?
Well, it makes me laugh a little bit because for the panelists, we've been talking about the House settlement in the NFCA for a while, right, as the litigation has unfolded. And I think that there was this expectation that once the order was signed, we're done, right? We're clear. And boy, you know, it doesn't even feel like, as Greg Sankey said in the ticker tonight, there was a quote, this is a marathon, and I'm not even sure we're out of mile one yet, right? I mean, this is going to be a long road as college athletics settles in to this new framework of how money flows, right? How does money flow? What is the expectation? And I think across the board, our coaches are used to rules where we're kind of operating in at least a band of the same space. And I think what we're going to see is a lot of differences, right? And I think your compliance officer coaches on the call should be your new best friend. If they're not already, Jody, you're my new best friend, you know, on speed dial. I think just trying to keep up with how your university is or college is going to opt in, opt out, fund your program, give you more scholarships, not give you more scholarships. I mean, it is going to change school to school. And so I think you have to have a very clear sense of where your school sits in this landscape, where your program sits within your school. And then as recruiting in September 1 for you Division I coaches and travel ball coaches is around the corner, be ready to have conversations where there are probably going to be a lot of expectations from prospective student athletes as to what's happening. And you're just going to have to navigate and feel very comfortable with the information that you can give. And then also feel comfortable with saying, I don't know yet, you know, or we don't have an answer to that yet, or that is not how we are running, you know, NIL or rev share here at our school. So there's some clarity, but I think what we're really interested in hearing, and I'm really excited, and I know it's on the agenda for soon, Joanna, is the Title IX aspect of this, because that has been a lingering question. And I think now we have some in the order, you know, some clarity, and then the appeals. So Ashlyn, we're thrilled that you're here to be able to talk about that. As a women's sport, there are a lot of coaches who are very eager to hear that piece, that, you know, element of this whole discussion.
Before we jump to that element, though, I'd like to go ahead and echo what both Matt and Samantha have said in terms of understanding your institution's position and your institutional opportunities. You know, whether your sport has rev share dollars or not, whether your sport has additional scholarships or not, because that will help you manage the expectations of parents and recruits. If you are not aware of what's going on, if you are not in the loop, so to speak, then it's going to be really hard for you to make that pitch or make that recruiting sell or talk about your program in a way that gets the travel ball folks interested, the travel ball coaches to continue to engage in the dialogue, whatever the level is that it might be. So to their points, I want to make sure that we emphasize the importance of understanding each institutional position could be different. And each institution has to make those decisions within the parameters of the settlement. So making sure that when you're talking, whether a travel ball coach on this session or a Division I coach on this session or whoever it is, making sure that you understand what is happening at that school and that it could be different from the school just down the road or across the country. And that that'll help you manage the expectations of not only parents, but recruits, and have honest, real conversations with people so that you're not over promising and under delivering, because that will get you in more hot water, coaches, than anything else. So make sure that you understand, where you're headed with these conversations.
Very smart. And right before we get to Ashlyn, because I don't want to hold anybody back from that, Samantha. So you segue me so wonderfully. I appreciate that. But I'm going to jump to Carol. Carol, you're also talking to a lot of coaches, hearing a lot of different, personal stories on what's going on. And they are so unique. We're 300 plus Division I teams and a lot of other divisions waiting to see what this will mean for them eventually as well. So go ahead and chime in here with some thoughts you have or information that you would suggest our coaches put into action.
Yeah, just speaking softball specific for just a moment. Again, as Jody mentioned, whether you're a Division I coach or a lot of high school travel ball coaches, I think there's a lot of just confusion and misinformation out there that now every Division I school has 25 scholarships. They're all getting a chunk of the revenue share from each individual institution. Oh, and they all have a collective that has quite a bit of money to be able to be distributed. And there can't be anything, just further from the truth. Every institution is different. There are some schools that will have 25 fully funded scholarships. They're very, very rare in the softball space, but there are some, which is better than some other sports, our counterpart sports. They're just sports across the country who may not have that increase in their scholarships at any institution, Division I institution, or there are some softball schools who are getting some revenue share dollars to distribute, and there are a lot of schools who are not. So I hear that a lot. There's a lot of confusion, frustration. The minute a young lady is being recruited, it's like, oh, they're going to now get X, Y, and Z. And that, again, you can't have enough conversations with those individual institutions, individual coaches talking to your athletic directors, your compliance officers, all of those things, your CFOs, all the people making those decisions. It's so important to have those conversations and then have some candid conversations with your prospects, the parents, and most importantly, a lot of the grassroots coaches, the high school travel ball coaches as well, because there's just all of a sudden, this legislation or the settlement, is moving forward, and not every sport, and I'm talking specifically with softball right now, not every softball program in Division I is going to see changes. Some programs won't see any changes. There will be no revenue share, no additional scholarships, all of those things. It's kind of business as usual, but there are a lot of programs where it will be extremely different. But those conversations are just really important to have.
Thank you, Carol. If you are looking for that FAQ document, just to reiterate, it is in the Q&A in the answered question. There's a link there, and we'll make sure you have that after the fact as well. Matt, you called this in our planning stuff a choose your own adventure for each institution, which spoke to my 1990s Scholastic Book Fair heart, because I'm pretty sure I read every choose your own adventure book that there was. And it is very unique. We're going to get into that more, but we we've teased like twice now for you, Ashlyn. So you are up. Give us a little bit from your perspective, the questions you are getting, the information that you think should be shared with coaches and others on the call, just wondering about the same thing Samantha is, the Title IX aspect of all of this.
Yeah, sure. And I'll start by providing just a high-level overview of Title IX because I know sometimes coaches aren't really in the nitty-gritty details of the law of it. But Title IX is a civil rights statute that was passed in the 1970s that applies to federally funded recipients. And specifically, as with regard to sports, it requires equal opportunity to participate in sports, equal financial aid, and equal treatment and benefits. So typically we see this in the context of female sports. You know, through this settlement, it has raised some questions as to whether Title IX can or should apply to revenue sharing payments in the House settlement. And that is both with respect to the damages portion and moving forward with the injunctive relief. So we looked at this settlement pretty intensely when it first got announced. And the various categories of NIL damages that were being paid. And we had a few people reach out that were interested in how Title IX might apply to the settlement. So there's roughly 4 categories of NIL damages that are being paid out to current and past athletes. Some of those are third-party NIL payments, so lost opportunities NIL payments. Those would be things like your typical NIL sponsorships and video games NIL. And then the other 2 categories are broadcast NIL and what's been deemed athletic services compensation. So the broadcast NIL payments are, generally for some sort of group licensing deals that athletes could have entered into with broadcasting companies, or through this stream of revenue sharing that goes from the conferences to the schools for the revenue that they get from their broadcasting deals. The athletic services compensation is essentially the back damages payment for what will be the revenue sharing going forward. And cumulatively, I think that makes up about 1.8 of the $2.8 billion. Somebody is free to fact check me on that. My math is not up to date, but we were looking at those thinking, are these payments that schools could have made at the time? And we came to the conclusion that the broadcast NIL payments and the athletic services compensation are payments that would have been coming from schools or conferences on behalf of the schools. And so we had a group of female athletes. I don't believe we had any softball players, unfortunately, but a group of female athletes from Division I institutions who submitted an objection in January challenging the calculation of the damages. Basically saying that those damages that would have come from the schools or the conferences on behalf of the schools should have been paid proportionately to Title IX. That issue, I mean, our objection was specific to that. I think that there were a number of other Title IX objections that were submitted on various other aspects of the settlement, but I'll focus on this one since it's the one that we made. That objection was largely unaddressed by the parties and by the court. I would say the plaintiff's counsel made some arguments essentially asserting that these were antitrust damages and that Title IX wasn't implicated in the case. And the court essentially bought that argument. So I think our clients would have been willing to accept, a more thorough explanation as to how Title IX could or should not apply to the damages payments, but they were frustrated by the fact that it was mostly, dismissed. And so they made the decision that they wanted to appeal the settlement to the Ninth Circuit. So I believe we were the first ones to file an appeal pretty early on. That has now been accepted by the Ninth Circuit. We have a briefing schedule set. I think briefing should conclude sometime in late October or early November. And then we will be set for oral argument before the Ninth Circuit. And then most likely it's going to take, I don't know, probably a year before we get any sort of decision from them. I think the important aspect that athletes have been concerned about, of course, is that the damages payments are stayed until that appeal is resolved. And a number of other appeals that have also come up since we filed ours. And, I think our position on that is we are in favor of a settlement. We think that athletes should be getting paid. We think that largely this settlement does phenomenal things for athletes and athlete rights. But we want the damages to be correct. And I think our clients, as well as a lot of current college athletes and probably many of the coaches and administrators here, would like some clarity as to how Title IX applies to these payments. And it is unclear to this point because Title IX and the regulations that govern Title IX were created before any payments like this were ever contemplated, or I think that anybody ever thought they could be paid. So there's nothing directly on point or directly governing these types of payments beyond just the legislative history of Title IX, which has in the sport world or the athletics world specifically been meant to provide more opportunities to female athletes, making sure that they have opportunities to participate and that they're getting equal treatment with male athletes and revenue producing sports. So that is really the main goal in this, is to get some clarity and ensure that the damages calculations are accurate. There's also two other pieces moving forward. So I think everybody has been waiting with bated breath to see the revenue sharing payments go into effect, to see if somebody's going to challenge those to say that they should be paid proportionately. I think most schools to this point, or at least the Autonomy 5 or 4 schools, have indicated that they will be revenue sharing consistent with the damages calculations in-house, which is, for those who might not know, 75% going to football, 15% going to men's basketball, 5% to women's basketball, and 5% to everyone else. So that's roughly 90% of the damages or more going to male athletes. And that will certainly vary a little bit by school and by the sports programs that they want to invest in. And I'm sure for some schools, they will be giving more to softball because we all know that there are some highly successful softball programs in the country. So that's one piece, is whether Title IX is going to apply to the revenue sharing payments. I expect we will see Title IX litigation arising as soon as the payments start getting paid out, or maybe as early as when schools start announcing their calculations for that. The other thing that I personally was not expecting, but has quickly come up as a very, very hot topic, is a number of schools have been cutting programs, and specifically Olympic sports programs, to essentially free up revenue to fulfill the full 20.5 million revenue sharing that the House settlement provides for. So we currently have 3 cases trying to reinstate some women's programs. I think that we will see more in the future. They were pretty last minute abrupt decisions to eliminate some sports. And of course, that's affecting Olympic sports and many women's programs as well. I'm not aware of any softball programs at the moment, but certainly swimming and some other larger athlete size programs. So that's what we're keeping our eye on. And yeah, I can answer more specific questions later.
Thank you, Ashlyn. I know we'll give some panelists a chance to jump in and either bring their own questions or come back around. Definitely difficult choices that athletic departments are making and have been making for a while. We do have a couple of softball programs that will not be competing in 26, and something we're watching as well for sure. Samantha, you're always the fallback legalese, being our consultant with the NFCA, but anything that you would add or anything you would ask on this front?
Well, Ashlyn, thank you for that. You should know that in December, when we were, talking about this at the convention, that was the question: does Title IX apply? And it seems like publicly there are many big voices, mostly on the defense side, that said no, it really didn't, right? And there are some who are saying we think it does. We think Title IX factors in here some, and I think based out of a fear that if it doesn't, then women's sports is going to take a huge step back, because we can see that looking at women's basketball, even you start to invest and there's growth. And so if there's not going to be an investment, it's going to be diverted to that 90% to the men, what will happen to women's sports? So we're thrilled, that you filed the appeal, that your clients were, brave and strong enough to go forward. And, we'd love to hear as we'll follow the case, as it goes, because it does have huge, huge implications for our coaches, of women's sports. Any concerns about the landscape, Ashlyn? Even as we get news that the Department of Education looks like it's going to be changed, we'll say, maybe dismantled, and kind of this sense from the administration that maybe, Title IX won't apply. Will Title IX exist? Any thoughts or comments on that? Because that is kind of an undercurrent, even as this debate is going back and forth. Does it apply or does it not? It all depends on how the federal government chooses to enforce it, and then how the judges, will uphold it. Any thoughts on that?
Yeah, it's a great question. And I think that was one piece that was going back and forth in the briefing between the parties on the objection was, what Department of Education regulations apply to this? The actual Title IX athletics regulations have been in place for decades. They have been largely untouched, and they're subject to just some, minor edits, I guess, through each administration. So, we saw in the final days of the Biden administration, they issued a policy interpretation saying that Title IX would apply to NIL payments, including NIL payments that were made by third parties. And then that was immediately rescinded by the Trump administration. I think given the, I guess, turmoil in the Department of Education at the moment, we're not really looking to them to enforce Title IX or to promulgate any sort of regulations that would provide guidance on this. And I also think we're not really looking to Congress for any sort of clarity because of course, we've all seen a lot of attempts to get some sort of legislation to govern college sports specifically, given how many competing laws and competing interests are currently overtaking this space. So I think our hope is that we get to court and we get a clear ruling quickly. My expectation is that there are going to be many different cases filed in different courts across the country that all have various different outcomes. And it's going to take a little bit of time for the legal system to kind of sort out how Title IX is going to apply from this. I do think that we're going to end up with some sort of controlling legal precedent. And, my clients would obviously be very happy if the decision was made that Title IX does apply to revenue sharing payments. But I think at this point, everybody is just hoping for some sort of clear rule to follow.
Well, we're glad you're in the Ninth Circuit. So here's for some hope.
Me too.
Greg, did you have something that you wanted to add? I just saw you come off mute, so I don't want to put you on the spot, but don't want to skip.
Yeah, no worries. I appreciate all the comments from Samantha and Ashlyn there. I just wanted to make sure that we understand what's currently subject to appeal and what has been decided and what's still undecided moving forward, right? What is currently on appeal is application and distribution of the 2.8 back damages payment to student athletes and whether those payments need to be distributed in a way that's compliant with Title IX. The methodology that was created to determine how those payments were going to be made was adopted by plaintiffs and their experts, right? Not in any way the NCAA or the conferences. So just want to make sure that we're understanding there. The defendants did indeed challenge class certification based, among other things, on Title IX implications, saying that each school will make independent individual decisions about how to fund each of their programs and all of their student athletes, whether male, female, or otherwise, right? And we thought that was an individual issue that predominated over the class-wide issues. So we had raised that challenge and we were overruled by the judge. Moving forward, though, I think, which is the most important for you all, and I'm not trying to minimize all of these other issues that are equally important, but moving forward as you're grappling with how to fund programs and teams and to comply with Title IX or not, that's a politically driven issue that is changing dramatically, and there's uncertain landscape. And so I would just encourage you all to work closely hand in hand with your GCs on your campus, in your conference offices, et cetera, to determine where the current presidential administration and law is and will be moving forward as you all try to implement this settlement agreement.
Thanks, Greg. I appreciate that. Anything else anyone wants to add currently on the Title IX discussion? And we may circle back to this. I just want to make sure we get to all the things.
I think I'm going to go ahead and just jump in and say, I think what's most frustrating that I hear from the coaches in kind of a very, very basic fundamental understanding of Title IX is that if there's an institution that receives federal funding, which pretty much is everyone, that as they receive it and as they spend it, that there's some equity among gender, that you're not treated differently based on your gender. And I think our coaches have a really hard time when they hear the 90%, thinking that that's not differential treatment based on gender. And I think it just is. I think what's hard is that schools really just want to keep funding football and basketball because they do drive the bus in college sports. But the impact that it's having, on women's sports or could have on women's sports is alarming. And it seems like, having just celebrated 50 years to get this kind of kick in the gut financially, with sports being cut or defunded. And while some are getting rev share, there are a lot that are getting cut and their budgets are getting cut in order to fund this rev share. It is hard to understand rev share, Title IX not applying to rev share, I think is what NIL as a third party seems different. But I do appreciate, Greg, your comments about, the NCAA's position in the negotiations and whatnot. But hopefully the litigation and the appeals do just clarify some of this, but it seems like we're at a precipice.
Thanks, Samantha. Appreciate that. Danielle, I'm going to come back to you because I know some people are thinking right now, okay, I've got this big book of NCAA bylaws, right? And there's a lot of things that are changing. So what are some of the things that are being addressed from a bylaw perspective that maybe coaches are used to seeing that, aren't going to be there anymore? Or, is my control F, is it going to get a lot less search results? Or are you going to cut a whole bunch of pages? Or what's it going to look like from a change perspective for you and your staff?
It's a great question. I think at a baseline, most of the changes already happened that are directly related to the settlement because we're past that July 1 deadline. So we had to do a lot of technology work on our end because there are changes throughout a lot of our different bylaws. Certainly our financial aid legislation looks different. The biggest one would be the removal of those scholarship limits that have always lived in our financial aid rules. A lot of our other financial aid rules are still there, though. The rules about when you can renew, when you can cancel, when you can non-renew, all those rules still look, for the most part, similar to what they would have looked like before July 1. Our roster related playing and practice seasons, the section that you would have gone to find those, when can we have a scrimmage exhibition, what games count, what don't count towards our season. That all for softball looks the same if you would go into that section of the rule book. The part in that same area, though, generally that looks different are the roster related pieces that Greg mentioned or that Jeff mentioned earlier. We now have, and you all are familiar, right, if your school is opting in, you have a maximum roster. Along with that maximum roster number, there's some nuance there about who has to count towards the roster, who can count towards the roster. When do I have to turn my roster in? Can I add people later on? When does my roster stop applying? All of these questions, once you all are moving closer to your season starting, that are going to they've been, your season cadence, you were used to it at that point, and these things will really impact, hopefully not in a bad way, but just the administrative part of your seasons will change as if you're working through this roster management piece. So that section of the rule book is a kind of a new add-on, but there are a lot of areas where we did simplify. I think the last major piece that and Jeff mentioned this earlier too, all of our Division I student athletes now are required to report NIL deals with non-institutional parties over $600 to the NIL Go platform that reports up to the College Sports Commission. So that's another piece that Bylaw 22 is where our name, image, and likeness rules have always lived. That got a little bit of a reshuffle, and now that reporting requirement is a primary piece of what that bylaw looks like now. And that, again, is something that over the last couple of years, your compliance staff, your student athlete development, if you have NIL folks on your campus, you as a coach your student athletes are used to that old structure where there was some on-campus reporting and reporting up through the national office. Now we have a little bit of a different structure. Similar requirement to report, but it's going up through a different end platform that hopefully your campuses have already started to educate you and your student athletes on. So that part will be a little bit of a change too. And we're here to help you. Your folks on campus are here to help you. And as I think Matt said earlier, this year we're going to get through it. We will learn a lot of things as we all go through this year. And then the year after that will look a little bit different because we'll be changing, evolving, and hopefully making it easier for everyone involved.
Absolutely. Well, a couple different directions to go there. And I know one thing with that roster designation and roster development in a spring sport that we're hearing a lot of. Softball has grown roster size rapidly in the last 15 years when we look at the NCAA historical data, and especially through COVID and the extra year. We are unique in our substitution systems and available reentry that we can use a lot of student athletes, sometimes even more per game than baseball, despite their pitching load. So for our coaches who this roster impact will be a challenge for them, we've gotten a lot of questions on, can we establish the 25-person roster December 1 and use it to intentionally redshirt players, right? Or how can we use that December 1 roster date to maybe work around a bigger roster in the fall, or whatever that might look like. Anyone want to go brave enough to tackle this one first? And there's a lot of sticky pieces here. Not everybody all at once, though. Can't be doing that.
I'll maybe take a first.
Yeah, Danielle, go for it.
And let the folks that have been thinking through this more from a campus year sports specific application. But I think what I would note is to just be clear, if that's your approach for this year, to make sure that you have talked to your compliance staff, read the rules yourself, if that's something that you want to do, to make sure you're aware of those students that would be being redshirted, that you and that student athlete understand exactly what they will and won't be able to engage in during that redshirt period. Because just want to make sure, again, expectations are aligned if they are going to not be able to come to practice, not be able to be involved with coaches or these kinds of things, just making sure that you don't leave someone off or make a plan that you haven't fully thought through the longer term implementation of.
Thank you. I appreciate you. And you kind of led us right to Jody. Jody, what would you add or what would you say?
Yeah. We're still learning. And so what we do know is, and what is clear is that spring sports have to have declared their roster by December 1st, because their first competition, is usually February or even January, right? There is, in my world, still a lot of discussion and confusion about what the fall looks like. That's different for fall sports, for fall sports who know that in the spring they still have to maintain their roster limit without any sort of overage, so to speak. So yes, I 100% agree with Danielle in terms of you only get 25. You get 25 scholarships and you get 25 roster spots if you're maxing everything out. I don't see a forum unless, and again, the other people on the call should correct me, but I don't see the intent or the forum where the medical red shirt, quote unquote, or the person who's not going to be at practice can keep their aid and get additional aid on top of that for your 25. That person can keep their aid, but that you don't get extra toward the 25 people that you have on your roster. So would be my 2 cents. And again, I welcome others to correct me if they have a different opinion or if I'm interpreting this incorrectly.
Now, I'll only add that I would just caution in terms of thinking of these scenarios as a red shirt in the traditional sense of what we think of red shirts, because when you look at these roster limit rules, if you're not on that roster, just how limited those students are in terms of what they can do during that year, which is really not much of anything in terms of even being in the facility. So I would just be careful. I would just caution you to make sure you're very much kind of read up on what those limitations are as you get closer to that December 1 deadline.
Thank you. Appreciate that, both of you. I think the other question, as we look at the December 1, is the mid-year transfer window, and how that changes things, or does it change things? Anything that our coaches should be looking at there. Matt, I know we haven't had you on the hot mic for a minute. What about any of this aspect? You want to jump in on any of that?
Yeah, a thought or two came to mind as Jody and Danielle, we're talking about some of the roster dynamics, and even in talking with coaches in other sports about everyone has their own version of, okay, how are we going to manage our new roster limit? And also the idea, I guess, 2 things. One, don't assume that 25 is the number your school is comfortable at for other reasons. We already talked about Title IX and some other pieces there, as well as cost, but also that, and others can jump on this, but just recalling that you leaving open spots on those 25 spaces in case you were adding someone later on, and Jeff and others can clarify, and Danielle, if that's accurate, but just thinking through sort of to double down on what Jeff said, it's very restrictive to try to have others sort of hanging around the program, if you will, and not be in that 25 is it's pretty stark. But I'm talking to coaches in some of the other sports is saying, things can evolve with portal windows, and that also is probably fair to say that none of this house settlement addresses the transfer portal period or those windows. So like some of the other things we're thinking about, and is it still going to be 4 seasons? Are we going to get 5 seasons of competition some point in the next few years? That also is not part of this. So as you're thinking about who we're recruiting and how we're recruiting and how we're building the roster, are we taking more transfers? That's just something else that it's a little tangential to the roster cap number itself, but something I think would be helpful for coaches to understand. Some of those other issues are still out there to be addressed in the years ahead, but aren't necessarily part of the house settlement.
Yeah, good point. Good point. As we look through the implementation on campus, right? I feel a little bit like I'm talking to someone that works in IT, where I get a lot of acronyms all the time, right? We've got NIL Go, and we've got the CSC, and we've got all these things that are happening. When you think about it from a campus perspective, for our coaches, as they enter into the process of now helping their student athletes navigate, how do we submit this $605 deal that we have, or how do we navigate this space? Can we talk a little bit about what the NIL Go process looks like, and then also some of the role of the CSC and what we've seen recently with collectives, and how might that all pan out? So huge big chunk of non-question there for you, but whoever wants to start with that, Danielle, I don't know if that's something kind of back on the campus front of how that comes together and what coaches should expect as they work with their compliance staff and also their student athletes.
Yeah. There's a lot there. I think we're just gonna have to do a little bit of all learning together. As Jeff mentioned earlier, the College Sports Commission is the CSC. They're new entity created by the settlement. They are getting up and running, and so they'll be able to answer a lot of these questions as well once they have a little bit more time to staff up and everything. Something I would go back to, not to kind of derail us, but back to what Matt was saying about want to kind of confirm that to roster limits, you as a coach were thinking that you might get some mid-year transfers. You could at this point submit a 20-person roster on December 1st on your deadline. And then you can always add as long as you haven't met your maximum. So that would be a way to manage rosters. And I think the other piece is, it looks like we're getting a lot of questions in the chat about the designated student athlete tag for our coaches who might be doing recruiting in the transfer portal. Maybe they haven't looked in there yet. I would just identify that the transfer portal profile of our Division I student athletes, if they are on a list as a designated student athlete, that's going to show up on their transfer portal. So as you're thinking about how you're doing your recruiting and how you might be doing your roster management, as someone mentioned earlier, right, our designated student athletes, they don't count towards that 25-person roster, whether they transfer to another institution, whether they're transferring back to the institution that gave them that designation. So would just make sure to be clear to folks as you all are thinking about managing your rosters that the transfer portal is a way to identify, as you're trying to think about how this all goes together, all the different puzzle pieces, the transfer portal identifying folks as designated student athletes should help you in thinking about how they would or wouldn't necessarily count towards your roster.
Coaches, keep in mind that, you know, the 14554, which is a bylaw that applies specifically to baseball, softball, and basketball, still exists. So while you may hold these spots that we're talking about, that Danielle mentioned, you may hold 5 spots for possible transfers. Without a waiver, those transfers are not eligible to compete mid-year. So they would start out as practice-only players. So just keep that in mind, that part of the rule that we have in softball has not changed.
Thank you, Jody. Appreciate that. Thank you, Danielle, for taking a stab at the Vegas non-question I could possibly think to ask. So appreciate you jumping in on that. Jeff, let's get you on the mic a little bit here with NIL Go. Just understanding how that works on campus. Can you walk us through that a little bit more for those who might not be in that space yet?
Yeah, I mean, it's really for both opt-in and non-opt-in schools. If a student athlete has an NIL deal, $600 or more, it needs to be disclosed, and that's really responsibility of the student athlete. Obviously, there's going to be a lot of institutional assistance with him or her doing that. But again, when I talk about us being kind of in a new era here, that Deloitte operation is independent of the national office. So they have a customer service line. You have questions about mechanics. How do I submit this? How do I use your website? That is every bit of function of their customer service. Their reporting line is to the CSC. So, there will be interpretive questions related to disclosure. I imagine there's certainly this eligibility issue hanging out there about, are there eligibility consequences for not disclosing, or what happens if it's discovered that a student athlete hasn't disclosed? But this is it is new, and I'm happy to help with kind of what the rule basically says and required, but it is just that if it's a $600 deal, it needs to be submitted to NIL Go.
Thanks, Jeff. Appreciate that. Greg, did you have something to add?
Yeah, Joanna, a few various thoughts as I've been listening to you all, specifically tied towards the transfer portal and the ability of Division I student athletes to transfer somewhat freely now, given an injunction that was issued by a federal court out in West Virginia a couple of years ago, right? The attorney generals of 7 states, including West Virginia, challenged Division I year in residence rules that said any multi-transfer has to sit out a year in residence before participating at their new institution. So a judge enjoined the NCAA and our conferences and schools from applying that national rule moving forward, which has somewhat created this chaos with student athletes transferring freely as many times as they want. Matt had mentioned that the 5-year rule, which essentially boils down to 4 seasons of competition and 5 years of eligibility, not being a component of the House settlement. That's true to the extent that the injunction doesn't directly address the national rule, the D1 rule. However, there is a component of the House settlement that says schools may limit or adopt rules or enter into an agreement which limit the benefits provided to student athletes consistent with 4 seasons of competition and 5 years of eligibility, right? And so I would encourage you all to think about and talk with the general counsels on your campuses and your coaches and your student athletes, et cetera, about if you're entering into an agreement to provide additional benefits to student athletes, is that a component of the agreement that you all want to engage in, right? That might have some type of a component of 4 seasons and 5 years of eligibility tied to any of those benefits being provided. So it's one tool or mechanism for you all to consider when deciding whether or not to enter into agreements with your student athletes.
Thanks, Craig. Appreciate that. Matt, with your information as it relates to NIL Go, I know we get a lot of questions of, is this a student athlete responsibility? Compliance staff what about the coach? What's the role? Who's reporting? All of these things. Any best practices that you have for people as they navigate the new space?
Yeah, I guess I have a kind of an overarching comment, not just about NIL Go, but the nature of the relationship between athletes and schools is changing under our nose. And I think schools, and I think all coaches are very familiar sort of with the notion of life skills. It's a really important aspect of the student athlete experience. But I think it's one area to maybe circle back with your staff and your athletic director and even like where is that line drawn about responsibility? And even though these are young people who are literally being thrust into real world business transactions and legal agreements, et cetera, I think there's going to be a reset, not necessarily moving away from, but a reset on exactly what the school's role is around life skills. So we all know financial literacy and other things. And so NIL Go, obviously, if it's an expectation, that certainly continue to be relayed about the reporting requirements that Greg and others have already alluded to related to 600 or higher NIL deals. But I do think that there is a notion, and I lived this when in the last few years when I was back on campus in the NIL sort of arena, and we see this in other dynamics. International student athletes have their own considerations with NIL and things like that. And at what point is the school's role sort of go this far, and at what point is it the athlete's responsibility? And we don't have enough time to delineate every single scenario that those come up, but it is something I think coaches need to be cognizant of and be maybe just double checking with your sport administrator, your athletic director about where is our new place in this role of helping develop in the life skills component when we're talking about things related to these transactions, and where does our responsibility actually end, and that we are probably a little bit more hands-off than even we want to be. That's something I think that's worth having a conversation back on campus about.
Good information. Jody, speaking of the on campus, just jumping to you. I know that, it's kind of tough, but in generalities, what are you seeing, or what would you encourage coaches to talk to their compliance staff about on their responsibilities, the student athletes, and navigating the process?
Yeah, I think that it's important, if you haven't taken the time, coaches, to read the Q&A document. I think there are a lot of answers in that Q&A document that, may spark questions that you want to ask of your compliance folks, that may cause questions that you even want to ask of the NFCA in terms of the global national picture for the sport of softball. We are telling our student athletes that you can have your agent, you can have your parent help you with these submissions, but you, the student athlete, have to be the one that hits the button to submit. because it's your eligibility, your students' eligibility that is affected by what's put into that system. And so making sure that they're aware of what's been attached or what hasn't been attached, what's been included in that submission, is really, really important for the student athletes to be the ones that hit that submit button in NIL Go. And coaches, make sure that your student athletes are not accepting any of those monies or benefits from those NIL deals until the NIL Go system has marked those as approved or reviewed them and marked them as approved. This is part of the things that we educate our student athletes on. Compliance has to help. Coaches have to help. Student athlete development, to Matt's point, and the folks who are dealing with the other side have to help. But we all have to understand what is required and what the consequences are of not reporting appropriately within the projected timeframes, whether that's ahead of time or the 5 days after or whatever it is, and making sure that our student athletes understand they cannot accept those benefits until that approval is given. So again, just making sure that we understand the basics of how the NIL Go system works, the basics of what is required of your student athletes, and then coaches helping them to get that information input, ask questions of the folks on your campus who have been tasked to be the point person for this. Who is it? If it's not your compliance person, who is it that is supposed to be knee deep or shoulder deep or over the head deep in this stuff? And go talk to them and ask them your questions. Go walk through the document with them if you don't understand. And if you're not getting the education pieces that you need, ask the questions of Joanna and others, and we can put together some documents to try to help on the softball coaching side of things. Again, that Joanna said this earlier, that's what the Coaches Association is here for. That's what these folks at NFCA are here to help you understand, and have webinars like this and put documents together, one pagers, whatever it might look like. So read through the documents, do the work on your own, but ask the questions when you don't understand what's happening, or if your student athletes don't understand what's happening.
Thanks, Jody. Appreciate that. Greg, I'm going to start with you because I'm not really sure who to ask this, but a question that we get a lot, especially in our head coach calls, is, what do schools have to disclose when it comes to their support of various programs? A lot of our coaches, from a competitive equity stance, they know that there might be a widening gap with what programs are doing to support, at different levels, different institutions. Is there something, whether it's now or in the long term, that will allow people to know, whether it's member institutions or the general public, who is sponsoring which sports at what scholarship level? I've heard, from the revenue sharing standpoint, the word proprietary used, that, we're not going to disclose this. This is a proprietary thing when it comes to allotments that schools are giving to different sports. But is there any way that people will understand, what is being done from school to school? And
Yeah,
hopefully
I'll jump in, Greg. You feel free
yeah,
to add. I guess technically, I think my answer is we don't know, but I suppose the likelihood is it's going to look like it has traditionally, right? Like even under the normal ways, there wasn't necessarily anything published to say, this school max, went to the scholarship limit, this school didn't, that type of information. But my assumption is that what is labeled proprietary now will probably remain that way. There's no duty or obligation for a school, for example, to unless it of its own volition, to say we're going to 25 scholarships, we're going to 19, we're staying here. It could be, I imagine, if it's a school that is greatly increasing their scholarships, they'll let folks know, because that's a positive. I got to think that's an aid in recruiting, but I don't foresee them being any kind of national rule obligating them to do so.
Joanna, if I can jump in on that just quickly. Schools do have an obligation under the Equity and Athletics Disclosure Act to report their participation numbers and their scholarship or financial aid that's provided. That goes to the Department of Education and is published online. There are a variety of state laws that have been passed that are trying to keep confidential the amount of NIL contracts, and likely that will apply to revenue sharing agreements as well. But in terms of how much schools are providing in financial aid per sport, and specifically between their male and female athletes, that is ultimately reported and lives on the EADA website. It's a few years behind though, so it won't be live updates.
Ashlyn, I don't know if you can answer this, but do you anticipate any of this being, or Matt, maybe being a FOIA thing? Like, do you anticipate that individuals trying to gain that information, and is that even subject to the Freedom of Information Act request?
I'm not sure if it would be subject to the Freedom of Information Act, although I'm not sure in particular why it wouldn't be unless the school tries to claim some sort of privacy concerns for athletes. I would anticipate, as lawyers in particular are looking to take these types of cases, that there might be some Freedom of Information Act requests because there is limited publicly available information to evaluate the strength of a case. I think it is, difficult for an attorney to make allegations, particularly in a Title IX case, based solely on, a press release from one university as to how they are revenue sharing, without more information on how much money is actually going to various sports, and in particular, overall female sports versus male sports.
And I would just add something we haven't talked about tonight, but each coach at each school is in a different place, is that there are different state NIL laws that are still on the books, and many of those state laws have expressly tried to address whether some records related to NIL and rev share are actually public records to start. So some of the state legislatures have tried to get in front of that in terms of whether things are FOIA-able, so to speak. And since we're talking acronyms, Freedom of Information Act, public records, this is primarily a public institution concern.
All the acronyms, Matt. We've got all the acronyms. One more thing to touch on recently, and it's, we talked about early, like what's new, what's newer, and what we're still figuring out. The recent CSC letter on collectives and how that will work. And I know that we've gotten some questions even in the last 48 hours about some of this information. I guess Jeff or Greg or Danielle, if anybody wants to speak to that, is there anything that we know right now, or are we still waiting on some of this information to work itself out with the legitimate business purpose side of some of these deals?
Jeff, I'm going to defer to you in terms of what you all are receiving from the membership by way of questions or otherwise. There's been reporting about things that are occurring or not occurring in the litigation that I'm not going to address at this point. But Jeff, anything?
Yeah, I mean, I'm not sure how much I had. I mean, that was a memorandum issued by the commission, right? It was not one done in collaboration with the national office, because again, it's their jurisdiction. My understanding is there's been some opposition to that. I think I've seen publicly reported some of the collectives push back on that. And I want to say perhaps even plaintiffs' counsel has gotten involved in that. So I think it's kind of a TBD right now in terms of settling on some of the guidance surrounding valid business purpose.
Yeah, I thought so too, Jeff. I just was hoping somebody knew more than me, but I appreciate the chime in, and definitely a lot of entities involved, and just things to continue watching. And we tell our members all the time, and I'm sure that also with, membership from the NCAA office, of just continuing to find information, seek out information, ask questions. I think sometimes we worry about being a nuisance, but in a space that's continually changing, it's a responsibility to really lean into the information and try to understand it as much as you can and find those who can help you. So I appreciate, again, all of you taking the time to join us and share. I knew this was going to go fast, and I knew we wouldn't get to everything. In some ways, some of you might feel more confused than when you started. In other ways, you might have found some really valuable information. And, honestly, I hope both is true, because if you get more confused, it means you're asking great questions, and that's a cornerstone of this whole process. But what I would like to do is go one more time around and just let you all comment on or bring anything up that maybe we didn't get to. We will just keep the same order alphabetically, because it's easy and I can make sure I don't lose anybody. And then we'll let Carol wrap it up at the end. But Matt, anything that you would jump on that we maybe haven't hit yet that you think is important?
I would say something we haven't talked about is that coaches are still here to recruit and build teams and develop talent, and I'm being completely sincere, because there's a lot of attention brought on all these important subjects, and in talking with coaches in different sports you can feel exacerbated and, oh my gosh, what have we gotten ourselves into? But we still have a job to do. These are still student athletes, they're still going to school, you're still building a culture, you have some new challenges to address. But I just want to reiterate that part of it, that technically we're not talking about tonight, but that's what you were brought to do, and you're still brought to do that. And it's a really important role that you all serve. So that's my finishing thought.
Thanks, Matt. Absolutely. Best profession ever. Can be tough times, but best profession ever. Danielle, anything you would add?
I think I'll build off of Matt's really good point. As someone myself who benefited from coaches and the college experience in an Olympic sport, you all are doing really important work, even though it seems challenging on lots of fronts at this point, and maybe this call did make you more confused. But trust in yourselves and all the experience that you have, that you all are making a really big impact on the lives of the student athletes and their families, and that impact will ripple out into the world, even if this is a challenging couple of years from a regulatory standpoint.
Thank you. Samantha.
Okay, I have three thoughts to share as we wrap up. First, I know everybody, we just desperately want like some finality and some clear guidance. And I think we've pointed to some resources. I think the Q&A from the NCAA is a great place to start. You should have it printed out on your desk and refer to it. Your compliance person, again, checking in regularly just to see what updates are coming. And just as Ashlyn said, it's going to take this litigation. This next round is still going. There's a congressional act, the SCORE Act, that we've not even talked about, that has been introduced and maybe, is the most promising so far in some federal regulation. We just have to buckle up and understand at your school, what are you allowed to say and what are you not? Where are you in all of this? And I think having regular check-ins with your sport administrator and your compliance is the best way to start, to have your own guardrails within this system that is still kind of figuring things out. The second is, as you are recruiting, which you all know, here I am, Jana, slipping it in, like recruiting, the most important part of your job, understanding and managing the expectations of the parents and the recruits, I think is going to be really key, because as they're reading things and, there are myths or inflated expectations, understanding what you can offer, what you can't, and then where that line is that Jody just referenced. I get very nervous as somebody who tries to defend coaches, kind of where that line of responsibility is, with NIL deals that are now external, and even the NCAA is saying that's an external entity. But I think, those conversations you want to be very clear with your recruits, and managing expectations, because even though money is flowing through, it's going to flow differently in softball and differently with each school. And the last one, which is most exciting, and here's a real tee up, the Title IX torch is alive, and we have somebody on here who's carrying it forward. And so we all remain very hopeful that the women will not be left behind in the implementation of the House settlement.
On that note, Ashlyn, you're next.
Yeah, thanks, Samantha. And I think I spent a lot of time kind of doomsdaying about Title IX and how this settlement and the future litigation is going to impact women's sports. So I will try to leave it on sort of an optimistic note, is that There is a lot in this settlement that provides schools a lot of opportunity to build on their Olympic sports and their softball programs and their women's programs across the board. Schools, now have the opportunity to provide far more scholarships than they were ever able to provide for softball and other Olympic sports. And there are schools that are going to capitalize on that. So I would encourage you to think about creative ways that you can use the new resources at your disposal through the House settlement to build your sport and get additional support from your school.
Thank you very much. Appreciate that. Greg, anything to add?
Thanks, Joanna. One thing we haven't touched on tonight, and it's the elephant in the room, it's the employment issue, right? A lot of questions about, okay, now that additional benefits in NIL can be provided, what does that do with respect to the relationship between student athletes and their institution? Does it turn it into an employment relationship or not? And so just a reminder that as we have great opportunity here, it's important that we're thoughtful and intentional about how we're providing those benefits or engaging in NIL activity. So we need to make sure that we're continuing to engage with the students to hear what they want, what is they believe is in their best interest, what type of relationship they want with their institution, and that we're intentional about the provisions and terms in those agreements to the extent that there are those agreements moving forward to make sure that we're not unintentionally triggering a legal relationship that we don't intend to do. So just something to be intentional and mindful of moving forward.
Thank you, Greg. Appreciate that. Jody, anything you would like to add?
I'll just leave you with marching orders, as I call it. Educate yourself and check your sources. Just because you read it on social media doesn't mean it's true. And please, please, please educate yourself in whatever format you can to be a resource to your student athletes, to be a resource to the parents, and again, check those sources.
Thank you. Great advice as always. Jeff.
Yeah, Jody really just said it. We've been talking about this stuff forever. It feels like we've been living in NIL forever, but in terms of this injunction, we've only been living under it for a few weeks. So it's brand new. We have not even done an academic year under it. So I encourage everyone at all levels to just really continue to educate yourself, because this is the way it's going to be going forward. And we're all going to kind of learn together in some respects, but we're all going to have to know it. So read everything you can and pay attention. It's evolving. We're continuing to get new questions, and that'll probably be the case for indefinitely. So we should probably circle back and do something like this again in some point, some kind of check-in mid-year, up to you guys. But I'm sure by then things will have changed once again to some degree.
Well, we will be in Las Vegas in December for our national convention. I don't know if you into it or not, but if you need a reason to come to Vegas, we are happy to provide you with one. Thank you all very much. Carol, any closing thoughts you would like to add?
Well, softball was an amazing sport before the settlement, and it's going to be an amazing sport after the settlement. I have no doubt. And I think a big reason why I really believe that's true and that softball has been growing and thriving because we have not been afraid of change. When we felt like we needed more offense, we, collectively decided, hey, let's take our pitching plate and let's move it from 40 to 43 feet, and we can see what's happened over the years. Some of our changes have been intentional, like that one. Or what can we do to continue to be attractive, to be a really exciting sport on TV? We've made a lot of changes, and we've seen the results of that and the benefits as well. And some have not been intentional. We've kind of been grouped in with a lot of other sports and a lot of other things, college athletics in general. Here we are with the settlement and sorting out our softball piece of the pie. But I firmly believe we are a group that is resilient, and we are a group that is very open to change. And I know we're going to figure all this out, and we're going to do it together. But the most important thing is that we take care of the sport, we protect the sport, our coaches, our student athletes, everyone around it, and use this as a springboard to learn more, to reward those who deserve it, and just keep our sport moving forward.
Well, thank you, Carol, and thank you again to our panelists. I appreciate you joining us, taking the time out to be part of this effort to assist our coaches. It is truly a testament to the commitment you all have for this sport and everyone involved in the profession. So thank you so much. And as always, reach out to us, education@nfca.org or NFCA.org on your social media platforms if there's more that you are looking for and you can't find. Thanks, everybody. Have a great night. It's been a pleasure, and we'll see you next time.